Good morning, everyone. Thank you for coming over. I've been to San Antonio several times. I love the invitation. I'm glad to see Al Flores. Al, I'm going to be calling on you. You got to put your phone down. He's one of our members. I'm with the National Restaurant Association, the Restaurant Law Center. So to my left, you got Jim. Jim is going to be the co-presenter today. He is a practitioner. So what that means is if you have a real question on how to handle immigration law, you're going to have to ask him. I did stay at a Holiday Inn last night, so that's why I'm on the panel with you guys today. We want to cover a couple of different areas. I know the panel talks about TPS, which is temporary protected status. We want to talk about that, but we were talking and we decided it will be maybe more beneficial if we cover a couple of other programs. So we're going to be talking a little bit about DACA, a little bit about DAPA, and we'll explain what all those initials stand for if you don't know. And then finally, we'll talk about H2C, which probably none of you know because it's a program that doesn't exist yet. But, we want to give you an idea of what we're working on in Washington, D.C. At the same time, you guys, it's a small group, so if you have any questions, feel free to interrupt us. There's a lady to the left that will bring a microphone to you so we can hear the question, and we'll be happy to answer it now or at the end. Other than that, one thing that I would highlight, the programs that you might be more familiar with as a restaurant are, H-2B, which is a temporary visa for usually ski hotels or places along the beach use it. There are seasonal jobs. J1s, is another program that is used a lot in the summer by restaurants, and there's a number of others, but those are all employment-based, meaning you have to do something about it. What we're going to be talking about is people in the United States that don't have permanent residency, don't have a work visa, like people would call it, but their status, by virtue of their status, they're allowed to have a work permit, meaning that you can legally hire them. So the question is not whether they're legal in the country or not. We'll explain the details to that, but the question is whether you can hire them or not. And the important thing about this is that it does provide you, we have been in Washington where I'm at, we get to hear from a lot of places around the country, and I think you will agree with these, but also from you guys, letting us know that there's a worker shortage. There's a lot of issues involved with that. I know that at least till September, there's going to be, in most places, extra payments for unemployment. It's $300 a week on top of whatever you're making, so a lot of people would rather, I'm not going to blame them, do that than get a job. So in the meantime, what do you do? And these are several million people that are in the United States right now and have work permits, so you can hire them. But with that, I'm going to pass it up to Jim, and he's going to talk about temporary protected status.
All right, so TPS, or temporary protected status, is really a status for individuals who are fleeing conflict. And so the president or Congress, they can designate certain countries to participate in this program, and there's typically a short registration window. And so once you register for the program and you get in, it can be renewed indefinitely. And so this is what's happened for a number of individuals. In fact, some individuals have been here in the United States on TPS status for more than 20 years. So one of the issues is how do we transition people to a more permanent status when TPS becomes not so temporary? And so that's going to be one of the issues that we're talking about today because an important Supreme Court case came out in this regard. Now, it's also important to know that even though there are a number of countries designated for TPS, once you miss a registration window, you're basically locked out. So you may have people from these countries, but if they miss a registration, they can't get in anymore. However, you will see that there are two countries, Burma and Venezuela, that are currently open for registration. And so we're going to talk about those two countries a little bit later on in the program because those individuals may be able to get their TPS going right now. All right, so what's the current state of TPS status? You've probably heard a lot about it in the news over the last few years, but at the moment, we're kind of back to the status quo. So what that means is there are a number of TPS programs, and those are continuing to exist. The Biden administration has extended several of those programs and has added a couple, like Burma and Venezuela. The programs that were trying to be ended under President Trump those got held up in court, and it's likely not to be a policy that the Biden administration is going to continue to pursue. So we expect that those programs will continue going on at least into the near future. Now, President Trump also started what's called DED for Venezuelans. This is a program similar to TPS, but it doesn't provide an immigration status, just protection from deportation and a work authorization document. The Biden administration went ahead and offered full TPS benefits to Venezuelans, and we're going to talk about that a little bit later on as well.
And if you don't mind me interrupting for a second. So I think you can see the pattern here of the countries that are listed, and maybe, to let you know how is it that a country gets designated under TPS, because it's really back to the country. It means that these people can be deported to these countries, but something happened. It's usually a natural disaster. If you look at Haiti, they had the earthquake a couple of years back. Now, it could also be political. If you look at Venezuela, their crisis there is really man-made, for lack of a better term, but the people that are fleeing are the people that pretty much agree with the U.S. position. But that's how you get in the program. And then, we always joke that there's nothing more permanent than a temporary program, so that's one of the reasons they stay there for a while. But move on.
For a long time, yes. So, okay, so temporary protected status, it's important to know that even though it's a temporary program, because people have been here for a long time, people want to get off of this kind of TPS treadmill, the indefinite renewals that go on and on, but there's no way to establish a more permanent status. So first thing to know, TPS in and of itself provides no pathway to a green card. So in theory, whenever this crisis ends, the program should end at some point in the future, but because it's been renewed indefinitely, there are now concerns about, sending people, back to these countries after they've built lives here in the United States. So how do we get off the treadmill? Well, individuals who have TPS may be able to get a permanent residency or a green card if they have a family or work sponsor. And so that's typically going to be the avenue for them to obtain a more permanent status. And to obtain a green card in the U.S., there are kind of three basic requirements that you typically need to meet. And these are going to be important for understanding the case we're going to talk about in a minute. So normally you have to have a lawful entry to the United States, so come in on a visa. Typically once you enter, you need to have been maintaining lawful immigration status, and then you need to be admissible. Basically, you can't have done anything that would preclude you from getting a green card under the law, such as committing a crime. So why is this a problem for TPS holders? Well, just by the nature of the program, people fleeing situations, like a disaster or conflict, frequently they enter without a visa, just because they're fleeing these bad situations. Also, they may have come with a visa but overstayed. The wheels of government turn slow, and so even if they came lawfully, it may have been a period of time before the government got around to actually enacting TPS. And so these two requirements for obtaining permanent residency are frequently hard to meet for many TPS holders.
And Jim, I'll add, for example, in the case of Venezuela, the government wasn't too happy about these people leaving. Pretty much the people leaving were the people opposing the current regime. So they weren't even issuing passports. They were making it very difficult for people to leave. So if you need a passport for legal entry to any country and your government is hostile to you and is not giving you one, that is going to be the first hurdle to be able to get legal entry. Go ahead, Al.
Absolutely. So
I think Al has a question if you don't.
Oh, go ahead.
I think I'm going to talk about Venezuela a little bit later, but just with regard to Venezuela and the TPS status, is there still, in terms of the other opportunities to get a green card either through a U.S. citizen here, for example, is there still advanced parole issues with those folks? Are they able to still do the advanced parole process and get back to the country?
So I had a little bit trouble hearing, but I think you're asking about advanced parole for Venezuelans, is that correct?
Right.
Yeah, so Venezuela, the registration's open right now until September 5th, so people who register and apply can get TPS benefits. You can apply for advanced parole once you're in the TPS program. Now, there is some case policy stuff going on with that. So normally, if you leave the country on advanced parole and come back in, that meets the lawful entry requirement for permanent residency. Under the USCIS policy, if you do it now, that's not considered a lawful entry. Basically, they changed the policy in 2020, and so they said that anyone who entered on advance parole before that policy went into effect can continue to call it a lawful entry, but after the policy change, you can't. However, the legal basis for that policy is pretty flimsy. And we anticipate that it will change in the near future. So Venezuelans who do get TPS status, I would encourage them to go ahead and apply for advanced parole, and they likely will be able to do that in the future.
With advanced parole, is that correct? So if the current administration modifies that somewhat, and they're able to get advanced parole, then they have legal status, they've got some documentation showing come back into the country. They can therefore use that and stay in the country when they apply down the road. Is that possible?
So, TPS allows you to stay here. And typically when you have TPS, you're not supposed to leave without this special permission to travel, which is advanced parole. But if you do leave and you come back in, that entry can facilitate the permanent residency process, but you still have to meet the other requirements. And so we're going to talk about this on the later slides a little bit, but if you can register now and be proactive, many Venezuelans, if they entered recently, may be able to avoid some of these common issues that we were talking about because they may already have some kind of status. They may have entered on a B visa. They may have been extending their B visa since they got here. So there are ways that, if they're proactive, they may be able to avoid some of these problems.
Practical note, for those folks who, with the employee shortage, for those folks from Venezuela, how is the connection being made with regard to, for example, getting those folks into the workforce?
Yeah, absolutely. So, right now, under DED, that was the first program that started under President Trump. They could start applying in January of this year. And so those individuals are just now starting to get their EADs, so their work authorization documents. The individuals who started applying for TPS for Venezuela, that became available in March, and so most of them are still waiting for work authorization documents. So they should be entering the workforce in the near future. And so really at the stage we're at right now, we want to identify people who are here that may need a status into the future and get them registered while they're still in the window so that they can work moving forward.
Thank you. And I would just add, not that you have any of these, but if you have a Venezuelan or anybody under one of these programs that use some other identification and then they come up and have new work authorization, definitely do the I-9 process again and put on the record that they have this new work authorization.
Absolutely. All right, so this gets a little bit technical, but it's important to understand the case that we're about to discuss. So when you're applying for permanent residency, there is a provision called INA 245K. And basically what that says is if you go through an employment-based green card process, so if the company sponsors it, you can have certain status violations forgiven. And so basically they only look back to your last entry. So you can imagine someone who has a different visa, like an H-1B visa. They travel in and out of the country all the time, and then they apply for a green card. The U.S. Immigration Service is only going to look back to their last trip at the airport to determine if they have been maintaining lawful status. So why is this important? Well, some immigration attorneys got creative, and they started making some arguments, and they were saying, hey, when people apply for TPS, they're letting the government know that they're here. They're giving the government an opportunity to ask questions about their case, and then eventually the government says they can stay. So that's basically the same process that goes on when you show up at the border. So when I applied for TPS, this is basically the equivalent of being admitted at the border. And so that's the same as the lawful entry requirement that you need to obtain a green card. And with this special employer-based provision, they should only look back to their last admission, which if the time they were admitted was when they got their TPS, this would forgive all of the status violations that might have occurred prior to obtaining TPS. So this is kind of the reasoning, and attorneys started making this argument, and a number of courts agreed. It actually started to allow people in TPS to go through employment-based processes using this and obtain green cards. And so this was available in certain parts of the country. However, not all the courts agreed. And so the Third Circuit, there was this case, Sanchez Vi Mayorkas, and essentially Mr. Sanchez was from El Salvador. He came to the US in 1997. He had no lawful entry and no status, and then when TPS became available to people from El Salvador in 2001, he applied. He had no violations after that, had an employer sponsor, and they wanted to bring him through the green card process, and the government denied his application. So he made the same argument that we were just talking about. I applied for TPS, that should be considered my admission, same thing as showing up at the border, and you should only look back to when I got TPS status to see if I've been maintaining my immigration status. But the US government, they took the different position, which was actually you need to show up at the border and physically present yourself with a valid visa in order to be considered admitted. And so that was the, their position, and the U.S. Supreme Court agreed with the government. And so this option in June, when this decision came down, went away. So it's not available anymore to the parts of the country where it had been available previously. And I think most importantly is this could have been a vehicle to take a lot of people who are here long-term on TPS off the treadmill, but now that option is no longer available. And in the Supreme Court's decision, they essentially kicked it back to Congress and said, hey, we understand this is a problem. There have been people here on TPS for 20 years, but you need to do immigration reform to fix this. This isn't something that we can do with a legal argument. And so while we're hopeful that immigration reform will happen, it's unclear when that might be. Yeah. And so what I want to talk about over the next couple of slides are ways that you may have certain individuals who are on TPS to figure out how they can get a green card in light of this recent adverse decision. So what options are still available
and
to
I
them?
would say, if you don't mind me interrupting for a second, the Supreme Court does this a lot. They often say it's not for us to tell you whether it's a good law or good policy or bad policy is up to Congress. So whether we think it's a bad law, again, Congress has to fix it. Whether Congress is not moving, that's a different matter, but that's something the Supreme Court many times just washes its hand and says, you got to do it in the legislature.
Yeah, absolutely. And so where does that leave us? These same people who are here on TPS for a long time and have lawful entry or lawful status issues, they're going to have issues getting off the treadmill. So what can we do? Well, for employment-based sponsorship, if you have a company and you want to sponsor one of these individuals, you're likely going to have to go through what's called a provisional waiver. So you can, test the labor market, file a perm, do all of these things to get someone a sponsor. But then what they're going to have to do, because they don't meet their requirements to get the green card within the U.S., is they're going to have to leave. So they would have to go outside the United States and apply for their green card at a U.S. embassy or consulate outside of the United States. And because they have immigration violations, in order to get in, they need a waiver or forgiveness for those violations. And so this provisional waiver, the good part of it is it's all done in the U.S. So they can be here on TPS and working for you. And if everything goes well, they may only have to leave for a few weeks and then come back as a permanent resident. However, to be eligible for that, we have to look at something other than just the employment situation, which is their family situation. And so to qualify for this waiver that they need to have a U.S. citizen or permanent resident, spouse or parent, and they need to suffer extreme hardship if they can't re-enter the U.S. So if you're thinking about permanent residency options for some of your TPS employees, we need to also start thinking about their family members. And it may not always just be completely obvious, because say you have an employee working for you and they have a spouse who doesn't have status, well, that spouse might be eligible for permanent residency. And so sometimes we have to kind of go a couple layers down the line to see, okay, well, can we get the spouse status? And then once we get them status, that may fix the situation for your employees. So it's really important to work with an experienced immigration attorney to try to evaluate all of these options to see if we can find legal room to maneuver. Now, family-based options. So the best family-based situation is going to be if there's an immediate relative. So what's an immediate relative? That's a spouse, parent or child of a U.S. citizen. So for your employees, that's probably going to be someone who has a U.S. citizen spouse or who has a child that's reached age 21 who can file a parent petition. And given the length of the TPS program, many people are approaching having children who are turning 21, and so that's, a possibility to consider. And so what's important about these types of applications, immediate relatives, is like INA 245K, immediate relatives don't have to have maintained status since entry. And so that part of it's forgiven. Additionally, TPS, like we were just talking about, allows for advanced parole, which is a special travel document as part of the program. So if you leave and come back in on advanced parole, which is permitted under TPS, you can meet both the lawful entry requirement, if you don't already, and have your status violation forgiven if you have a U.S. citizen spouse petitioner or if you have a parent or a child who can file a parent petition. So those are good options if those situations apply. Now, the other family-based options are out there. Maybe you have a permanent resident spouse. They can file a petition as well, but they're going to have to go through that same provisional waiver process that we talked about with the employment situation, because status violations aren't forgiven unless you have a U.S. citizen petitioner under the immediate relative category.
And while they get a microphone to Al, I would expand. This is the problem. This is why I would call him if I had an immigration question, because it is as complicated and as contradictory as you can hear. What we're talking about are people that have a legal status in the United States, right? They got this TPS, they got one of these status which give them a work permit and tells them you can stay here legally. If they want to become permanent residents, if they want to tell the country, hey, I'm planning on staying here forever. There are laws in the book that says if you're outside of the United States and you're trying to come in, if you have been here illegally for X amount of period of time, you are prohibited from coming in from anything from 10 to 20 years, depending on how long that is. Then you have this law that says if you want to change your status, you have to do it outside the country and then come in. But when you try to come in, you say, my wife is American, my kids are American, I actually work for so-and-so restaurant, here, my work permit, whatever. They say, yes, but there's this other law that says we got to keep you out. And that's where all these waivers and all of these things come in. Again, in the discussions that we have been having in Washington now for over a decade on immigration reform, these are some of the things that we're trying to fix, because we're saying it doesn't make sense. If you're legal in the country, if you have your family in the country, why leave? Why not charge us a fee? Let the government make an additional $1,000 or something, and you do the paperwork here, as opposed to forcing them. It's good for the airlines, I guess, and the hotels abroad, forcing me to go abroad and go to the consulate and the embassy, and then trust that the individual at the border would go like, oh yeah, I understand all of this, you can come in, as opposed to like, yeah, I don't think so. You go back and you figure it out. But Al, I know you had a question.
I was just curious, under the family-based option and the employment-based option, has the public charge requirement been modified any? Or do you still have to have the same public charge threshold under the previous administration?
So the public charge requirement that President Trump put in place, so it's always been there, but he made it a point of emphasis and put out some new policy guidance to make it more difficult. There was a form that had to be filed that required basically all of your financial documentation that you could imagine under the sun. So it just became kind of a more onerous process. The Biden administration has gotten rid of that. And so the public charge requirement is still there, but it's kind of reverted back to the way that it was applied pre-Trump.
And one of the things that we were talking about that maybe you can expand is under COVID, you have the whole issue with consulates closing and others, but also the immigration law is still when you talk about forms, those are new hurdles, because those forms are still required to be paper forms. It's not like, now you can buy a car online without ever talking to somebody, but in immigration, that's not the case.
Yeah, absolutely. The immigration system, they've been trying to make it more technologically advanced since the early 2000s, but now I think there's 3 forms that you can file online, and the process doesn't work very well. So it's still very basic when it comes to dealing with the government, and that creates delays in processing. And that's something that we're seeing with COVID. You file these things at service centers out someplace, and they have social distancing requirements and limited staff and all of these things, and they have to go through thousands and thousands of pages of physical paper files to process, and it's created a substantial backlog in the processing. So that's just something to be aware of too, as things are very slow right now, but we're hoping as things improve that will turn around. But all of these processes, they take years to complete, and so it's important to start early, because it's not something that's going to turn around right away.
Not to mention that you have to trust the postal service to deliver, because usually they use PO boxes, so you cannot use FedEx or UPS. So good luck with that.
Yeah.
But go on.
All right. So apart from the employment-based and the family-based options, asylum is always an option. It's typically less desirable than an employment or a family-based situation, because one, the denial rates are extremely high, more than 50% typically. And also, if you are accused of filing a frivolous asylum application, there's a bar to all future immigration benefits. And so that can be very serious and adverse, and you don't want to fall into that bucket. So the other option that's up there is cancellation of removal. That's also a way to get permanent residency if you're in a deportation proceeding. So TPS holders are actually protected from deportation, but in the future, if a country designation were to end, this could be a route to obtain a green card. It provides relief to people who have certain family members in the US who have been here for more than 10 years. So there are some options that might be out there, but typically people are trying to resolve this as quickly as they can, and so employment or family are going to be your principal means. All right, so Venezuela. So this is kind of what we were talking about a little bit earlier, but Burma and Venezuela currently have registration that's open for TPS. So this is your chance to kind of get into the program if you want to do that. Venezuela is particularly important for Texas because there's such a large community here. And September 5th, that's the cutoff for registering. But the earlier you register, the more likely you are to catch them in a time frame where they either haven't violated their status yet, or they've done it for less than 180 days, in which case they may get some benefits through the employment-based processes. So register early for TPS if you have individuals that may need that status in the future, and that can avoid some of these obstacles that we were discussing.
Can we get the microphone back here? Right. Thank you.
What's the difference between continuously resided in the U.S. and continuous physical presence?
Yeah, so those are two separate requirements. And so basically, continuously residing, when they set a specific date for TPS that you need to show residence since. So when you apply, you need to provide bills or other things to show that you've been living here as of that date. If you showed up 2 days before that date, you may have trouble establishing that you've had continuous residence. Now, physical presence essentially means that once you've come here, you weren't supposed to have left the country before you apply.
And those 2 dates are usually different, so residence is longer. So let's say you prove that you were here 5 years ago, but then you prove that you haven't left for the last 2 years.
2 years, yeah, exactly. So for Venezuelans, this is a really good option. It's a really good time to apply. TPS can provide a lot of benefits. Now, what gets confusing is we had talked about President Trump started this DED program, and so that also provides a protection from deportation and a work authorization document, but it doesn't provide an immigration status. And so you may have people who are coming to you with a work authorization card pursuant to the DED rather than the TPS. So it's important that your employees or potential employees know about the difference in these programs, and if they're eligible for DED, they're likely eligible for TPS, and they should go ahead and apply for TPS, because that's going to give them more options in the future for obtaining some sort of more permanent status. And with that, I think I'm going to hand it back to Angelo to talk about some other important programs.
Thank you. So again, any other questions on TPS before we move on? Perfect. So we wanted to talk about a couple of other programs that or at least one that still allows for people to get workers, for restaurant to get workers, legal workers. So first of all, anybody here, I know Al has because he has asked me tons of questions about it. Anyone else heard about DACA before? Almost everybody, yeah. And I could continue asking you questions because I used to be a law professor and we like using what is called the Socratic method, but then I learned why they poisoned Socrates, so that's the only question I'm gonna be asking you guys today. So anyway, DACA, Deferred Action for Childhood Arrivals, was created in 2012 by President Obama. It gave work permits, and pretty much what it says was, not that you're not here unlawfully. It says, yeah, you're here unlawfully, but there's also 11 million people that are here unlawfully. Well, no one really knows the number, but at least 11, and we have a lot of other people on our priority list. If you have committed a crime, if you are in jail and you're about to get out, there's a number of people that are on the list before we get to the children. So you can stay in the country legally. We're not going to persecute you. We're not going to send you back. And while we're at it, here's a work permit so you can go work. Why is that important for restaurants? Well, we have an estimate that says there's 1.75 million individuals that qualify for DACA. If you look at the workforce in the restaurant industry, about 40% is between 16 and 20. And a lot of them are students. So this is a sweet spot where we get some of the entry level. So suddenly we have 1.75 million potential new workers. Now, not all of these people apply for the program. I think it's about 800,000, do you know? Yeah, it's about 800,000 that have gotten the benefit. A lot of them, why people do not apply for these programs, you may ask, or I'm asking for you. And the reason is they just don't trust the government, right? They're like, well, why do you need my information? And what happens if I get declined? Now you know where I live. Now you know about my family, because again, some of these are children, and that's why they don't give it. But still, you had about 800,000. Again, the program was expanded in 2014, and we'll talk about the legal battles that took place, but it pretty much stayed in place until now. And the last executive order is more like a memo from the president, was a memo to DHS, the Department of Homeland Security, saying, I want you to expand it and strengthen it. And we'll talk about what was the case. There were certain requirements to be able to get to DACA. Anybody heard about the DREAM Act? Right? I drafted that baby. Anyway, I was at Maldives at the Mexican American Legal Defense Fund. I'm not very creative with names, so it was called the Student Adjustment Act. But it wasn't even an immigration bill, it was an education bill. It was done during George W. Bush. It had a lot of bipartisan support. The DREAM Act name actually came from the Republicans. Senator from Utah, Orrin Hatch, introduced his version of the DREAM Act. It was a lot more narrow, but they came up with the name. So at the time, they were more creative. The two bills came together, and it became the DREAM Act. But the idea was the Hispanic community had a high level of dropout rates, particularly in Texas. Bush was, whatever you want to say about the man, for immigration purposes, for a job, he was very, very good. And he understood the issue from having been governor of Texas and having such a large border with Mexico. And he knew that they had an issue with the dropout rate, and the idea was, usually in families, and you would have experienced this, a lot of these families have what we call mixed families, meaning the oldest child came with the parents when he was very young, so he will be undocumented. The younger children were born in the US, so they're documented, they're US citizens. So what happened is, the older one, realizing he couldn't go to college or join the military or anything, will drop out and start working. Well, then suddenly he's telling his siblings, hey, you can go work at this chicken factory and get paid $10 an hour. Why are you going to college? So the whole idea was, let's make sure if we give a big incentive for these individuals to stay in school, then the other ones will follow. So the original, I was not the immigration lawyer at Maldives, I was education lawyer at Maldives. It was an education bill. But it has morphed into certainly an immigration bill. You have a number of other ways of getting into the DREAM Act, if it was enacted into law, and DACA, including the military, that did not exist on the Student Adjustment Act, student being the main purpose of the bill. So anyway, DACA takes some of the requirements and tried to legislate it through an executive order, and he put these requirements. living here under age 31 by 2012, as you mentioned earlier, on continuous residence. They're always trying to put dates on because they have to put the line somewhere, and what they want to do is not encourage like a new wave of people saying, oh, I'm going to go so I can take advantage of DACA. No, if you weren't here in 2012, too bad, you do not qualify. And then, of course, the education and then armed forces component. We started with Orrin Hatch and the Republicans, and I thought it was a great addition. That's also another way that you can qualify is if you have unhonorably discharged from the military. No felony or serious misdemeanor convictions. There's a number of additional requirements that I don't go over, but just so you know, don't commit a crime. So this is how you qualify for the initial DACA, as it is called. Then there was another program that was announced. So when DACA was issued, by the way, when DACA was issued, it was not challenged. You would have heard about the Supreme Court case. We'll talk about how that got there. But when DACA was issued, it was not challenged. It was allowed to come into force. Why? I think it does have, and the DREAM Act itself has a lot of bipartisan support, both Republicans and Democrats. And I thought they weren't on the, those that would challenge didn't think that was the opportunity to go in and say, you know, we're gonna start challenging kids' opportunity to go to college when you have valedictorians and others graduating from high schools here in Texas as well to challenge that program. So the program was not challenged, and it came into place. You know, they started giving applications, people started applying, people started getting work benefits, and we had at the National Restaurant Association show and board meeting, we had one of the first DACA recipients, you know, the woman that now handles the a foundation for DACA students. And while she was speaking with us, you know, she got her announcement. And interestingly enough, she was working for a restaurant as well. And she was able to talk how in her hometown, you know, so many of these kids went to work for restaurants. So anyway, DAPA, on the other hand, was a program that was created, Deferred Action for Parents of Americans, and I like to add LPRs. It's not just Americans, but the bill is known for DAPA. It's Americans, but it's also legal permanent residents, which means people that have a green card that you touch upon a little bit. It was announced right at the end by President Barack Obama on November 2014, along with the extension of DACA that I mentioned. Now, the program was never implemented. One of the problems that we're having now, I also do labor and workforce law, and that's an even bigger headache, but the Trump administration did a number of good regulations for us. Anybody take the tip credit here? Any restaurants take the tip credit? There you go. So tip credit, we like what Trump did, but they issued at the end of the administration. Every time they do that, there's going to be litigation because courts know, yeah, you're just on your way out. And also, they do not take their time to take the proper steps with regulations where they do it, as we say, midnight regulations in a hurry. But this one came out. Don't take too many notes because it was never implemented. But I just want to mention it to show you the similarities and then what happened in the Supreme Court. Again, it had similar requirements, living in the United States without interruption since 2010, physically present, and this is what we were saying. You were asking presence, residence versus physically present. They said, you know, you have to be here since 2010. Without interruption still allows you to have some travel in there. Physically present does not really. So they want you to be here physically for that amount of time. Now that you went back to Venezuela, check out how things were. They were still bad. You came back. That could disqualify you. And then you were in the country already, physically in the country, applying from the program. You were not doing it on the consulate or the embassy. And you had a child in the United States at the time that was either a U.S. citizen or a legal permanent resident. And again, the no felony or misdemeanor conviction, that you will see it in a number of laws. So before we get into the cases, that one was challenged. And I think that rightly so, and Texas was one of the states that challenged it as well. They thought they had a much better argument and that this group of people weren't sympathetic. You can make an argument for a 2-year-old who was put in a car and driven across the border with the parents. He was innocent, right? He's just going with your parents. Now they're saying, well, wait a second, now you're asking the parents that brought these kids to also get protection. No, they knew what they were doing. So they thought, here we have a better PR argument, not permanent residency, but public relations argument that we would do with the other one. So they challenged this particular program. Very similar One was the children, the other one was the parents of U.S. citizens mostly, and they both get work permits. And that is the key, the fact that they're getting work permits, because no one is questioning the fact that the government can decide who to persecute and who not to persecute. For example, I know none of you are doing this, but most people on the highway, not you, would drive, 2, 3, 4, 5 miles over the speed limit and never get stopped. Because police officers are making a determination that says, we're not gonna stop anybody that is going over 7 miles the speed limit. So 5, 4, 5, 6, 7 gets you off the hook. After that, we'll stop you and then we'll prosecute you. Funny story that I got from a cop I used to teach at the police academy. He said, I stopped a priest once, and he said, son, you gotta forgive and forget. And he said, Father, I forgave the first 7. It was the last 3 that I couldn't. So Daca is similar to that, right? We got 11 million. You can say, we're gonna prosecute and we're gonna kick out all of these other people first, and then the children, you don't need to worry about it. For the next 2, 3 years, here's your work permit, go to work. So the Trump administration decided that they were going to rescind Daca, right? They said, this is no longer valid. They said it was illegal and they had no choice. Several courts stopped him it's an injunction from rescinding the law, the regulation. And then the Supreme Court decided, 5-4, that the rescission was unlawful because there was insufficient justification. What does that mean? Everybody comes and asks me, well, if Obama, people on both sides, and I don't take a position except when I represent my clients, people on both sides like, well, if Obama was able to do this through an executive order, why wasn't Trump able to undo it through the same mechanism? If you look at the decision, and that's why people hate lawyers, and I'm surprised more of them are not poisoned, like Socrates was. He was not a lawyer. But how come he wasn't able to do it? The Supreme Court didn't say he was not able to do it. What they said is like, you didn't do it right. The explanation that he gave, again, there was not a legal challenge saying that is illegal. And the Supreme Court said that might be illegal. The fact that they got work permits might be illegal. But that's not what is in question here. You're not a judge, you're not the court, you're saying it's illegal, so I will, and then he also said, I would love to keep it. It's not because of me, it's because they're forcing me to do it. And the Supreme Court is like, no one is forcing you to do it, and if you're gonna do it, you have to give us a reason. Any reason. It can be a semi-bad reason, but it cannot be no reason at all. So it was bad procedure, the way they did it, and then they ran out of time. They had an acting Secretary of State try to do a memo, try to undo it, and they said, you don't have any authority, you haven't been confirmed by the Senate, so you cannot rescind it that way. So the law is still in place, the executive order is still in place. It doesn't mean it's legal or illegal. It hasn't been challenged for those reasons. On the other hand, you had DAPA. DAPA was challenged right away by a number of states. They said, this violates the Constitution. Why? Because it's up to Congress to pass the DREAM Act or the DAPA Act or whatever they want, giving them work permits and permanent status and everything else. The injunction was issued blocking the program by the court, and it made it to the Supreme Court. So the Court of Appeals in the Fifth Circuit said, we think that this program is illegal because only Congress can give work permits. If you look at the immigration programs that some of the ones that Jim just mentioned, it is very tricky as to whether, you can be here legally and not have a work permit. You can be the spouse of somebody that has a visa to teach at a university, a UT or something like that. You're here legally, you're a tourist. You can be a tourist here, you're legal in the country, but you don't have a work permit. You can only work if Congress says you can work. And what they said is, deferment, you don't want to prosecute them, you don't want to kick them out, that's up to you. Work permit, you cross the line. So all of the law, all of DAPA falls through. So those people, whether they're here in the country or not, if they're here in the country, you cannot employ because they don't have work permits. So the difference was when it got to the Supreme Court, it was 4-4. One judge was missing, one justice was missing, and that was Judge Scalia, just died. So when it's a tie, there's really no majority, so the court below remains. If they had another case, maybe, because the Supreme Court never heard it, but we had an election and we have Biden, and Biden is not touching DAPA, he's concentrating on DACA with the explanation. So in 2017, and this is the difference as well, in 2017, Trump rescinded DAPA. But now he has a court order that says this program is not valid. So he said, okay, the court is telling me. He didn't have that in DACA. He said, well, they told me that over there, so I'm going to do this over here. And the Supreme Court is like, no. Maybe it's illegal, but we get to say that, not you. And that happens a lot. You know, they like keeping their jobs, so I guess, you know, that's one way of doing it. So that's the main difference between the two programs. So in DACA, you have 800,000. I expect more of the 1.75 million to apply. I don't know, have you seen if there's an uptick or they're waiting for the applications to be reopened?
Sure, and I think one of the important things with the court injunction was for a while you could only renew your DACA, but now it's been reinstated so that people who never applied but were initially eligible can file new applications. So if they had never applied for DACA before those Trump administration policies went into place, they can apply now. So yes, there should be more.
Correct. So again, and that was one important reason to have work with administrations on labor laws and other laws is one of the reasons the Supreme Court case gave was like, well, wait a second. You gave all these people this benefit. These people are already working. These people already came out, you know, as we say, you know, come out of the shadows, raise their hand, trusted the government, which is why I think the other half of the 1.75 million didn't apply, because they know, well, wait a second, what if Trump changes his mind? He said, these people came forward, raised their hands, told you, gave you all their information. In exchange for this promise, you give them a work permit, you give them this visa or status, and now you're going to kick them out? You didn't even ask for their opinion. And that's what the Supreme Court says. You have to take in consideration that you're taking something away. Yeah. And the United States is very big in our Constitution that if you're taking anything of value, and a work visa is very valuable, but your house or anything else, there has to be compensation or there has to be some consideration. The courts will not just go ahead and take your rights away that easily. So that's what happened, and that's where we are now. So we have DACA and we have DAPA. Now, H2C clearly is very interesting, the programs that restaurants have to work with. There is no program that has been designated for what we call essential workers. Those are restaurant workers, hotel workers, cleaning workers. If you're in high tech, if you're Google, and I know you represent a lot of the high tech people, you have the H-1B visa. Those are for the technical people. If you're in agriculture, if you're on the other end, if you're the supplier for the restaurant industry, you have the H-2A visa. Yeah. So agriculture has their visa, high tech has their visa. If you're seasonal, well, you know, maybe if you're a seasonal restaurant, you got the H-2B visa. But there is no visa created for essential workers. We have an opportunity now because under COVID-19, finally the term essential worker became popular, and now people realize who the essential workers are. You know, people were thinking, well, essential workers. I used to go to Congress and say, we need a visa for essential workers. It's like, what is that, nuclear plants or whatever? It's like, no, our workers, they're essential. Suddenly COVID-19 happened, and they say everybody can go work from home except you guys. You guys are essential workers. And it was the same workers we've been talking about all along. So everyone knows there's a shortage. We've been pushing for H2C. It's a letter that is available is C. They already took A for our friends in agriculture. They took 1 for our friends in high tech. So we're like, hey, give us H2C and create a new program. So there's a lot of legislation that have been introduced. We expect that it's probably going to be the hardest. You have a large constituency in the agricultural lobby. You have a large constituency in the high tech. You have a lot of Democrats pushing for a portion of legalization of the DACA and others, but creating a program for our industry is still going to be an uphill battle. So these are some of the requirements. What I've seen is in the debates that we've been having, 3 years, that's what the high-tech people get. Let them change jobs, if they come and work for OWL, but you have a restaurant, you want to offer them more money, they can transfer. We're saying we're not trying to tie anybody to an employer. We're willing to test the market. But right now, there's no doubt, there's $92 million jobs available in the United States right now. It's the highest it's been in decades. So there's no question that the jobs are there. Let's see if we can bring a program where people can come in legally, as opposed to they came in illegally and now they're looking at DACA, they're looking at TPS, they're looking at their spouses. Let's do it right from the get-go so they don't have to cut to the line. So that's the H2C program. If you hear anything about something like that, we want you to come to Washington and lobby on it. And with that, I don't know if you guys have any other questions. We have 10 minutes. So we have our contact information there again. If go, oh, no, let me see. There you go. So anyway, there's our contact information. If you have any questions, feel free to contact us at any of those numbers or the email. Take a picture. Al knows how to get a hold of me, and I'll be happy to forward to Jim. So with that, thank you so much, and thank you for your hospitality.